हॅलो काय बाबा
जा. ते ना इकडलं दाब ते बघ.
कोण आहे? प्रतीक सरांना माझं नाही ते प्रतीक हे राव सर आहेत. स्टॉप करा. वेलकम. Good afternoon, sir.
Good afternoon.
Chirag, sir, good afternoon.
Good
Sir,
afternoon.
with your permission, shall we proceed further?
Please take permission of Rao sir.
Yes, sir. Rao, sir. Yes, sir. Rao, sir. Always there is a permission of Rao, sir. Thank you, sir. Good afternoon to all. I am Professor Dinesh Kolte, coordinator of this 1 week online workshop series on Indian Penal Code. Warmly welcome to today's resource person, Honorable Professor Chirag Balyan, Assistant Professor, Maharashtra National University, Mumbai. I cordially welcome all the participants throughout India. I heartily welcome our beloved Principal Dr. Simrao sir. Today's resource person is going to enlighten us on the most important topic, that is principles of criminal liability. I hope definitely it will benefit us to understanding and to comprehending all the concepts of the principles of criminal liability. Once again, I welcome you all on this 5th day of session on this series. Thank you, sir. Over to Kaushal.
So may I begin?
Yes.
Crime is the truest reflection of how and where the society has to amend itself. A very hearty good afternoon to one and all present here. I, Kaushal Singh of BALLB second year, welcome our Principal Rao sir, teachers and coordinator, and our resource person for the day, Professor Chirag Balyan sir, on the online lecture series organized on the Indian Penal Code by MLNGE Society, Manikchand Pahade Law College, Aurangabad. The resource person for the day is Professor Chirag Balyan sir, Assistant Professor at MNLU, Mumbai. We welcome you, sir. The topic for the day is General Principles of Criminal Liability. Before I request sir to proceed, I would like to introduce sir to all of our attendees who are joining us here in the live meeting as well as via YouTube. Our resource person and guest for the day, Professor Chirag Balyan sir, needs no introduction. As on date, sir is an assistant professor of law at MNLU Mumbai. Sir also holds the additional charges of being Coordinator, Center for Arbitration and Research, Deputy Director, Center for Research in Criminal Justice, Coordinator, Center for Maritime Law and Research, and Faculty in Charge, Mediation. Sir was previously a research assistant cum law clerk at the Honorable Supreme Court of India from August 2014 to July 2015. Sir has been a resource person for a plethora of roundtables, workshops, webinars for numerous law students. Sir was also the resource person at training program of judicial and government officers on POSCO Act at Nasik in March 2018. Sir was coordinator of one-day orientation program for police officers of the Coastal District of Maharashtra in Maritime Matters in January 2019. Sir has served from 2015 to 2017 as the course director of training program on mediation and negotiation. In fact, very recently in December 2020 itself, Sir had the pleasure of being the coordinator of training program for public prosecutors of Maharashtra on victims from commercial sexual exploitation. Sir has co-edited a book revisiting reforms in the criminal justice system in India, printed by Thomson Reuters 2020. Sir has authored numerous research papers on constitutional law, administrative powers of the Supreme Court, cryonic preservation, sentencing policies of the Apex Court, to name a few. It's our sheer pleasure and honor to have you, sir. Now I request sir to please take over. Thanks again, sir.
Thank you, Kaushal, for the kind introduction. And at the outset, I would like to give my sincere appreciation to Dr. C.M. Rao, Professor Kolte, and other organizers to give the attention which is due to Indian Penal Code. Indian Penal Code is one of the most important legislation in our country, and I'll discuss it during the course of lecture. But in a world where there is lot of conversation about corporate banking, privacy, information technology, revisiting Indian Penal Code assumes lot of importance, and that is why I congratulate Dr. C.M. Rao, Professor Kolte, and the other organizing members of this 1 week lecture course. I am deeply gratitude of Dr. Rao and Professor Kolte to invite me, and I'm humbled that an opportunity has been given to me to speak in this program. During the remaining 1.5 hours, I will be discussing the general principles of criminal liability as mentioned by the organizers of this program. So let me just project my PPT, which is for my reference so that I do not deviate from the point, and then we'll start in a second. Give me a second. Whether my PowerPoint presentation is visible?
Yes, sir.
Thank you. So let's start. Let's start from the very basic proposition. What is criminal liability? Now, this is one particular question which we usually ignore. And when you undertake a course on IPC in your law school, generally the major emphasis is on the sections or the specific part of the criminal law. But for one reason or the other reason, the general part of the criminal law does not got that much attention in the Indian academia. And therefore, there is not much conversation about that what is criminal liability, why do we need criminal liability, and what are the principles which govern criminal liability. Now, the term criminal liability reflects that there is the strongest social censor which a state can impose upon an individual. When we talk about the relationship of an individual and state, because all of us as individuals live in this state, and there is a legal system, there is a rule of law regime which is set up in this state. Now, if you violate the norms of the state or the society, then criminal liability is the strongest social censor. There is nothing beyond criminal law which a state can do. This is the maximum and this is the strongest measure which a state can take upon an individual who violates its rules. And that is why I said in the beginning that the study of Indian Penal Code, the study of criminal liability is not much appreciated, though the consequences of the application of Indian Penal Code or the application of the criminal liability are far-fetching. We all have been learning Article 21 of the Indian Constitution. No person shall be deprived of his life and personal liberty except with due procedure established by law or except or without procedure established by law. Now, what is this? This article is said to be the heart of the Constitution, and it protects two things: life and personal liberty. And criminal law takes these two things, life and personal liberty. And therefore, the topic itself assumes a lot of importance. That what are the circumstances or what should be the circumstances the state is permitted to breach one of the most important fundamental right which it itself has guaranteed to the citizen. And this question also reflects upon that what should be the scope of the criminal liability, to what extent can a state go in depriving someone's life and personal liberty. And because it concerns this one of the most cherished principle of the constitutional law, and the criminal law threatens the deprivation of article 21, therefore we say it is the strongest tool in the armory of the state. So unless we understand the seriousness of the criminal law, because what happens when we become lawyers, then it becomes very casual for us to talk in terms of first information report, arrest, pre-trial detention, jail, conviction, acquittal. But these are very heavily loaded terms. All these terms carry a lot of social stigma. And therefore, what are the appropriate cases in which the application of the criminal law is warranted assumes lot of importance. Then I move to my next point. What are principles of criminal liability? I have just talked about what is criminal liability. Now, basically, principles of criminal liability lays down normative and legal basis to utilize the criminal law. So the underlying argument is that you cannot use the instrument of criminal law in a blanket manner. Take an example, we are having this conversation. Tomorrow, state comes and say, no, you can't have this conversation. And if you have this conversation about the scope of criminal law, then that in itself is an offense. This is problematic. This is problematic on both normative grounds, legal grounds, as well as constitutional grounds. So what principles of criminal liability does is that it provides a framework to the state that whenever you are enacting a criminal law, then these are the considerations the state shall keep in mind. And if the state does not keep those principles in mind, then what would be the consequences which will follow? Now, the other objective of principle of or laying down principles of criminal liability is to identify the behaviors where criminal law can be utilized. Now, as you will see in my next slide also, that in society, in our mutual existence, we talk in terms of right or wrong. This person has done right, that person has done wrong. So every action of a human being is judged as right or wrong. Now, right is right, right? But then how do we address the wrongs? Or what are the kind of wrongs which should be addressed by the state? What are the kind of wrongs which can be addressed by the society itself? And by which instrument or tool these wrongs should be addressed? That's the fundamental purpose of identifying the principles of criminal liability. And therefore, the principles of criminal liability helps us in identifying the underlying logic of IPC, underlying logic of sentencing policy, underlying logic of the penal policy. But the real question which has emerged since 6-7 decades, especially last 6-7 decades, for India, it is post-independence when we started expanding our economy. It is since last 6 decades that question has started coming up whether there are really any principles of criminal liability. And if yes, what are those principles of criminal liability? So today what I am going to do, I'm going to tell you that what are presented to us as the principles of criminal liability. I'm not saying those are the principles of criminal liability. I'm telling what are standard textbooks or what is taught to us as principles of criminal liability. And then I negate that on what grounds it is not appropriate to label them as the principles of criminal liability. Now, in the previous section, I talked about wrongs and criminalization. Now, to understand principle of criminal liability, we need to identify that why some wrongs are criminalized. Now, why breach of contract must be a civil wrong, and why stealing must be a criminal wrong? What are the principles which determines the judgment of the legislature, that how the legislature decide that if the contract is breached, then we will use the civil law. Then if theft is committed, we will use the criminal law. If murder is committed, we will use the criminal law. If partnership is broken, we will use civil law. Consumer disputes are essentially civil in nature, but the offense pertaining to what we say cheating is a criminal wrong. So, this is the fundamental answer which a state or a reasoning which a state has to apply. In India, we could not do so, and for rightful or the wrongful reason. The reason is that to us, our bulk of criminal law, which is contained in IPC 1860, was given to us by our colonial masters. So we really could not apply our mind to the questions that should defamation be addressed by the criminal law or by civil law? Should nuisance be addressed by the criminal law or by civil law? Should adultery be addressed by the criminal law or by civil law? Should questions of homosexuality be addressed? Should question of sedition be addressed by the criminal law or by civil law? Because these are the two major tools which any state has to deal with certain kind of behaviors which the state proscribes or say that these conducts should not be done. Therefore, because of our colonial masters, we as Indian citizens, though at that time Macaulay and his team tried their best to get the public opinion, but at that time public was not very well informed. The laws which were published for taking public opinion were published in the English language, and not many had the privilege of knowing English at that time. So if you refer to the minutes published by the Macaulay, who is the draftsman of the Indian Penal Code, you would understand that why a law which is meant to govern Indian could not understand the requirements of the Indian. And that is why you would also see that now Ministry of Home Affairs has set up a committee for reforms in criminal law or criminal justice, which is headed by one of the former vice chancellors of National Law University, Delhi, Professor Dr. Ranbir Singh, and Professor Dr. G.S. Bajpai is the convener. So they are saying now we will investigate the principles of criminalization. We will investigate the principles of criminal liability. We'll see that how criminal law can be used in a principled, effective, and efficient manner. So if you look at the preamble or the objective of that committee, which is working on reforming the criminal law, they are looking at how criminal law can be used in a principled, means there should be some principles for the use of criminal law. Principled, effective, and efficient manner. Now, that's one of the landmark movement in our constitutional jurisprudence, in our criminal jurisprudence, that such kind of committee has been set up, which will look the overall landscape of the criminal law. On earlier occasions, Law Commission have examined. They have examined some sections of the criminal law. Should we have sedition? Should we have defamation? Do we need to overhaul IP? But the overall basis of these legislation, the overall basis of these laws were not examined. And the need of examination these legislation is very well amplified by some of the recent judgments of the Supreme Court. So if you look at the judgment of Joseph Shine versus the Union of India, which has decriminalized the offense of adultery, then just read the opinions of the judges which have authored this judgment. You would identify that there is some element of principle they are talking about. Or one of the essential principles which Justice Chandrachud talked about, that criminal law should not treat women as the chattel. Means any law which objectifies the woman, which treats women as a property, deserves to be struck down. That was the principal reason for striking down the offense of adultery. Different judges have given different opinion. Justice Nariman approached it from purely religious ground because it is one of the religious concern also. Justice Indu Malhotra took a different route. She examined constitutional law principles. She examined some theories of the Western criminal justice philosophy. And then Justice Deepak Mishra and Khanvilkar approached it from a different way. But if you read that judgment, what you would be able to identify is some principles. But then the real question is, are there some set of principles which we can say, okay, these are the principles. So if today I have to decide that X thing should be declared as a crime or not, do I have some ready-made principles that I can use criminal law or I can use criminal liability? Now, there are various approaches to it, or at least when I say there are various approaches to it, I mean to say that scholars of criminal law have used these approaches. They have tried to identify the principles of criminal law by examining the definition of crime. Whether the definition of crime tells you about that what are the principles which governs it. The experiment, the exercise was highly productive. Even the greatest of the criminal law scholars like Glenville Williams, who has authored a wonderful treatise, General Principles of Criminal Law, ended up saying that criminal law is where criminal procedure is used. And criminal procedure is where the criminal law is applied. So he gave a circular definition of crime. He defined crime in relation to criminal procedure, that offenses where you apply or the trial is conducted as per CRPC, then what essentially you are talking about is crime. Now, he is one of the biggest scholars of the criminal law. He has to come to this definition because he could not identify a definition of crime which encapsulates, which contains all the principles of criminal liability. And therefore, he gave a very, very procedural definition of the crime. Then there are a couple of the philosophers or the scholars like Smith and Hogan who gave a definition of crime which really or technically does not reflect the principles which a state apply in determining criminal liability. And it is because of this reason that there are no principles, technically speaking, or there is absence of principle. We know that a lot of debate happened when triple talaq legislation was enacted. That should triple talaq be a crime or not? On what basis will you decide the criminal liability? Whether using criminal law as a tool, which in the first slide I used is one of the most severest step can be taken in a democratic liberal state. Whether criminalization of triple talaq is appropriate. I'm not giving any answers. I'm not giving any sides. My emphasis in raising this issue is, can you identify principles? The fact that both sides had their argument, which to the respective supporters sounded sound arguments, means that principles are very diverse and often divergent, and therefore very difficult to look at these principles. Then second question which I have raised is, third question which I have raised is, can we identify principles by examining the content of offenses? Now, if you observe question 2 and 3, I have changed one word. I have changed the word or substituted the word offense instead of the word crime. Now, IPC does not use the word crime. Though we read criminal law, we read law of crimes, but the IPC does not use the word crime because of the reason I stated. It is very difficult to define crime. And therefore, legislature defined the term offense in IPC. And offense is anything which is defined in IPC or which is defined in any special statute or in any local law. So again, it's a very generic definition of the offense. By looking at the definition of offense, you can't determine on what basis criminal law is used. But then second question is, can we identify by principle by examining the contents of the offenses? So when I say contents of the offenses, what I really mean is whether you can identify principles by examining the ingredients of the offenses. So whether there is something common in the ingredient of the offense of murder, in the offense of theft, in the offense of criminal conspiracy, in the offense of sedition, in the offense of defamation, in the offense of dacoity, in the any other offense. Now, because of the paucity of time, it's just 1.5 hour lecture. I can't tell you what are the similarities or distinctions. But what I can say is that it is very difficult to identify general principles by looking at the ingredients of this section. Two general principles which we often talk about is principle of actus rea and res rea. Many of you must be having this in mind, but I'll come to it at a later stage. But I'm emphasizing it. There are no general principles which you can identify. There are few scholars who have attempted to do that, but there is no consensus as to those principles as well. And I will discuss the reasons, what are those principles and why there is no consensus on those principles. And therefore, this lack of consensus or absence of general principles led many people to argue that we are living in the era of over-criminalization. Now, the term over-criminalization may be new and novel to many of you. Many of you might not have heard this term, that what is over-criminalization? Now, Douglas Husk, who is one of the prominent criminal law scholar of the United States, define over-criminalization as a situation where there are too many laws. When a state decides to address every kind of criminal law without determining whether it is efficacious to use the criminal law or not, whether criminal law brings the desired result or consequence or not. Apart from that objective consideration, state use the criminal law. That's one way of looking at what is over-criminalization, that is incessantly, without thinking, without applying the mind, just keep enacting the criminal laws. Second way of looking at the term overcriminalization is looking at the content of the criminal law. That the manner in which it is appropriate that criminal law is used to address this wrong, but the manner in which criminal law is used is not proper. So this argument, I'll give very simple example. This argument is used in many terrorist offenses. You say that under the UAPA Act, Unlawful Activities Prevention Act, now any person can be declared, individual can be declared as a terrorist. Now people say this is an instance of an over-criminalization, not because the state cannot decide who is terrorist or not. State very well has that power, but the manner in which it is done is not appropriate. In one of the very what we say usual or daily examples, let me try to explain what excuse me, what overcriminalization is. So now we all know what is the offense of robbery. Robbery basically need two elements. First, it need either theft or extortion, and second, it requires imminent danger to life or imminent danger to your body. That immediately hurt will be caused if you do not deliver the property to the person. That is the robbery which we usually discuss. Now, when robbery becomes overcriminalized, now take an example. You in your college, all of you are 18 years old, right? Threatens your friend, okay? You just pick that person from his collar and snatches his pen and say that if you do not give me the pen, I will hit on your face. Now, technically speaking, you will not label this person as a robber. Being a robber is, carries a lot of social stigma. It is a very heavily weighted word that this person is a robber. But technically speaking, this person has committed the offense of robbery. Snatching a pen is not a very costly thing. It may be a 2 rupees pen also. Threat of harm, immediate threat of harm. It may be a punch. It may be a small prick also. The law does not define the extent of the harm. Law does not define the extent of the property. So we say that the language of the section is couched in so broad terms that some of the innocent activities of the adolescents may also be criminalized. Say from your brother, okay? Now, criminal law does not say that you can't commit offense of robbery against your brother, elder brother, younger brother, elder sister. You fight with your brother and snatch his chocolate. That is a robbery in the definition of IPC. So it's in that respect, or one way of looking at the phenomena of overcriminalization. Yes, the laws are defined in very broad terms. Now, if you remember Section 66A, popular Section 66A of Information Technology Act, which was couched in very broad terms, and the law was reviewed in the judgment of Shreya Singhal versus Union of India. Justice Rohinton Fali Nariman struck down that law. On what ground? That the terms used in Section 66A are very broad. So the court annulled the law on the ground or on the doctrine of vagueness doctrine. That you can't use criminal law when you have such vague terms. It is an unnecessary fetter on the freedom. There are various freedoms illustrated in Article 19. One of them is freedom of speech and expression under Article 19(1)(a). Article 19(2), there are reasonable restrictions. Now, those reasonable restrictions sometime might be utilized in the criminal law, but couched in very broader terms. In those circumstances, you would see that law has been struck down. But offense like robbery is so normalized, or we generally do not debate, And there are thousands of such offenses. And I discussed that, some of those examples. Now let's move to next slide. Now, when I was talking about principles of criminal liability, and many of you who have read IPC or who have read law of crimes must be thinking why this person is constantly saying that there are no principles of criminal liability, or if at all there are principles of criminal liability, there is no universal or general consensus on them. So let's reflect on that point and what is the standard or the basic position. Now, basically in criminal law, we talk about act requirement and the fault requirement. And the maxim which I've stated in my screen, actus non facit reum, nisi mens sit rea. This maxim basically embodies the principle of criminal liability. Excuse me for a second. Embodies the principle of criminal liability. Now, what does this maxim mean? This maxim means there cannot be a crime without a wrongful act and without wrongful intention. Means every crime needs a guilty act and a guilty mind. And this is in criminal law is called requirement and fault requirement. And it is said that every offense must have these two things, actus rea and mens rea. And if you remember your IPC classes, or if you have read IPC, your law professor would write on the blackboard or the whiteboard, crime is equal to actus reus plus mens rea. And actus rea and mens rea are the general principles of the criminal liability. But when I say that they should be general principles of the criminal liability, what I am saying is that in every offense, these two ingredients must be there, irrespective of what offense is that. But as I would argue, or I would show you in some time, that there are many offenses where there is no requirement of mens rea. And there are many offenses where actus rea in the strict sense does not exist. And there are some offenses where without actus rea and mens rea, you are liable. Now, you would say, this is something which is unheard of. How it is possible? I'll give you examples in the meantime, in the subsequent slides. And therefore, I say that this proposition is highly contestable. Now, there are at least three principles of criminal liability, or at least this is my bifurcation, you do not find in any book. So first are the substantive principles, which I've been talking about. And when I talk about substantive principles of criminal liability, I'm talking about on what basis wrongs should be identified to be treated by criminal law. These are the substantive principles of the criminal liability. Actus rea and mens rea supplies these substantive principles. Then we have evidentiary principles. Now, in strict liability offenses, no, the term strict liability, I'm not sure if you have heard, but strict liability offenses are those offenses where the proof of mens rea is not required. So I'm not saying that the mens rea is not required, guilty mind is not required. What I am saying that prosecution do not have to prove the mens rea when the prosecution is proving the case in a court of law. Now, we all know that the fundamental principle of the criminal jurisprudence is that the burden of proof lies upon the prosecution. Prosecution has to discharge proof beyond reasonable doubt. And when I say that prosecution has to discharge its proof, but essentially we are saying if prosecution has to prove the case of murder beyond reasonable doubt, prosecution has to prove the ingredients of the offense. Prosecution has to prove that the ingredients of the offense has been satisfied. And many a time you would see that in the ingredient, there is an element of actus rea and the mens rea. Those are not the contestable issue. Offense of murder in some sense has both actus rea and mens rea, and you all know why, right? Offense of murder talks about intention. Offense order talks about knowledge, it talks about negligence, it talks about conduct, it talks about consequence, which is death. I will discuss about murder in some more detail, but my emphasis on this point is that when you have committed the offense of rape of a girl less than 18 years of age, you may have mens rea, you may not have mens rea, but law does not require you the proof of mens rea. This is the evidentiary principle of criminal liability, and these are strict liability offense. Strict liability offenses in that sense are the challenge to the general proposition that in every crime there should be an act and guilty mind, or act requirement and the fault requirement, because in strict liability offense proof of fault requirement is not required. So already the emergence of the strict liability offenses. Now, what are the legislations? Take an example of Essential Commodities Act, or take an example of NDPS Act, or take an example of prevention of atrocities against SC/ST Act. All these legislations are strict liability offenses. In fact, if you do a survey, you would find that in India there are more strict liability offenses than the normal offenses. It means there are more offenses which do not require proof of mens rea. So my question is, why are you talking about that in every crime there should be an act and guilty mind? Because 90% of the offenses in India and abroad as well does not require mens rea. So what is that general gospel truth you are talking about of requiring the twin requirement of actus rea and mens rea in every offense? That's false, or that's at least half true. Then second, where I talk about the procedural principle, is the increased use of reverse onus clause. Now, just a moment back, I told you that one of the general principle of the establishing criminal liability is that the prosecution must establish it, and prosecution must establish it beyond reasonable doubt. But now you would see that there are more and more offenses where the legislature is using the reverse onus clause. Now, what happens in the reverse onus clause? If you look at triple talaq legislation, it's a mixture of strict liability offense and reverse onus clause. Now, in the reverse onus clause, what happens? The burden to prove that I don't have the mens rea is upon the accused. Now, in traditional offense, burden of proving the mens rea is upon the prosecution. But in reverse onus clause, the reverse happens. Onus is shifted upon the accused. You prove us. You tell us that we should not say that you had a guilty mind when you committed that act. Now, the principle of burden of proof has its own value, its own rationale, that by it is one of the most celebrated principles. But you would see that increasingly in the legislation, instead of presumption of innocence, there is a presumption of guilt. Right? So presumption of innocence is again now no more a settled principle of criminal liability. You would see many legislations like POXO Act. POXO Act specifically talks about presumption of guilt. Now, this is very contentious area, that you say that principle of presumption of innocence is the golden thread of criminal jurisprudence, but then you have POXO Act, wherein you are saying if some specified offenses are committed, then it shall be presumed that the accused has committed the offense. So basically, the impact of reverse onus clause is on the procedural safeguards. The procedural safeguard is that the prosecution must prove the case and not accused. The responsibility should not be accused. So that's why I say that, the proposition is contestable, because be it the substantive principle, evidentiary principles, or the procedural principles, all of them, if not eliminated, are diluted to a large extent. Then I move to next slide. Then we talk about, let me talk one by one about ectasia and mania and why individually also they are problematic. So when I talk about ectasia, so first thing is why we should insist on an act in a crime. Why act should be proved. Now, basically, this requirement of act flows from the theory of rational agent or from a theory of a responsible individual. Now, we all know that crime is committed by an individual, right? Crime cannot be, IPC is not applicable to animals, it is applicable to person. And those person are individual. Individual is a unit. Even if you look at some of the latest judgments of Justice Chandrachud, be it Sabrimala, be it your Joseph Chang judgment, be it your Section 377 judgment, all those judgment you would see is constantly talking about that individual is the basis of our fundamental freedoms or the constitutional rights. So there is a lot of emphasis upon an individual as a unit. So now this individual is considered as a free and rational agent. So take an example, if I picked up this mug, I wanted to pick this mug, that's why I picked this mug. I'm a free individual. Because I have a freedom, I could pick this mug. I'm a rational individual. Being rational means that when I pick this mug, I evaluate it, whether it is appropriate to pick this mug or not. So we talk in terms of rationality of an individual, and we presume that every individual is free and rational. That's the fundamental premise of the criminal law. Because I can do what I will, I want to lower my hand. I have lowered my hand. I wanted to do it. So what I'm saying that the movement of my hand, I have a control on my body. I have an autonomy over my body. So we say an individual is an autonomous being. I can decide for myself. I know what I'm doing. And it is the central basis that why we require an act or why we insist on the act requirement. Let me give you an example. Twitching of eyes. Twitching of eyes means aankhein fadfadana. Now, when your eyes twitch, whether you do yourself, answer is no. You do not commit that act. Now, though you are a rational being, you are a free being, and what you do is voluntarily, there are few things in life which you do not do voluntarily. Twitching of eye, it's not voluntary. Somebody scares me, say someone comes from behind and I react. I do not act voluntarily. So there are certain circumstances when I do not act voluntarily also. Someone puts a gun on my head and say, okay, do this thing. Not voluntary. So there are circumstances when I am not able to act as a free and rational being. Though I have my rationality, but still I could not act as a free being because there is someone who is influencing my decision making. So I talk about coercion, but coercion is an external element. There are many a time internal element also. Say there's a swamp of bees or a group of bees. You are driving a car and they attack you. Your windows are open. Now what you do because of that attack is not voluntary. There is some external agent which affected, and say in that accident someone dies. Have you committed an act? The question is, someone dies in that accident. Have you committed an act? Have you satisfied the act requirement? The answer is no. It's not just act, act should also be a voluntary act. So if you see, I think we have section 39 where the term voluntarily is defined. Any act is not criminalized unless the act is a voluntary act. So you would see, if you refer section 84, even in section 84 of the IPC, which talks about intoxication defense, there's an element of voluntariness. They say that if you do not consume the alcohol yourself, you do not consume yourself. Somebody forced you or somebody mixed in your normal drink, in your soft drink, and then you do something. Because intoxication affects you as an autonomous being. You cannot act rationally when you are intoxicated, and that's why the law says you are excused. So those are also called excusatory defenses. The law says you are excused from the criminal liability. Again, that's the principle of the criminal liability. You are excused. Take an example of insanity. If you are insane, you do not have control over yourself. You do not know. You cannot act as a rational being. You cannot act as a free and autonomous individual. There are various diseases which come under the umbrella of insanity. I'm not getting into that, but what I'm impressing upon you, you may commit an act. But if that act is not voluntarily done, then there would be defenses, there would be excusatory defenses, and in those cases, criminal liability will not be attracted. So technically speaking, you haven't committed the act. In the eyes of law, though you have committed, you have done something. And it is for this reason why we insist on act. We insist on act because we treat individual as autonomous people. Now, this act requirement manifests in various forms. So if you do a survey of IPC, you would find two kinds of offenses. First is result crimes, and second is causation offenses. Now, I was talking about murder and I said I'll come back later. Now I'm coming there. Murder is an example of a result crime. Now, which act you do is immaterial for the offense of murder. You put a knife in someone's stomach, you use a pistol, you throw someone from the 15th floor, you administer the poison. The very act which you commit is irrelevant for the offense of murder. I'm not saying it does not exist. It may exist, but I'm saying it is irrelevant. What is relevant is whether what you have done has caused the death of an individual. So your liability is dependent upon the consequence. If the death happens, then you are liable for murder. If the death does not happen, you are liable for attempt to murder or you are liable for grievous hurt or hurt, depending upon which act you used. But ultimately, what we are talking about is the consequence. Similarly, the offense of grievous hurt, your arm is broken by someone else. How that arm is broken is concern of no one. Have you caused that consequence? How? Doesn't matter. So these are consequence crimes. So act requirement manifest in different forms. So consequence, technically speaking, is not an act, right? So if I say that in every crime there should be an act and fault, so technically speaking, there is no act in the offense of murder. What I'm talking about is the consequence, but that is an acceptable thing, okay? Act itself is requiring or is manifesting in the different forms. Then there are some conduct crimes, where what is criminalized is your conduct and not the consequence. Take an example, stalking. Now, the consequence, the impact on the woman of the stalking is irrelevant. What you are doing? Conduct. What is your conduct? You are constantly monitoring the activity of someone. So the offense of stalking is affected. But constantly monitoring the activity of women is not an offense in itself. It becomes offense in certain circumstances, and it becomes an offense if done by certain individual. So if a police monitors a woman constantly for the purpose of investigation, then that's not the offense of stalking. So we are not saying that the entire conduct is criminalized. No. What is criminalized is the manner of doing that conduct. Say, when you perform the surgery as a doctor, the person may die, and say the person died because of your surgery. Now, therein, the conduct is permissible conduct. Technically speaking, you should not engage in something which may endanger life of someone. But as a surgeon, you did because it is permissible conduct. So we talk in terms of permissibility of the conduct and not so permissibility of the conduct. Take an example of the offense of rape. Now, having sexual intercourse in itself is not an offense. It becomes an offense when done under some of the circumstances specified in the section 375. So section 375 in fact is also an example of where the act requirement is satisfied. So if after 2013 amendment you look at the definition of rape, it has talked about 5 kinds of act. I need not go into what are those acts, right? But it talks about 5 kinds of acts, wherein penetration is not even or not required. Even manipulation of the body part is enough, and that's offense. But if a surgeon manipulates that body part, that's not an offense, because that's not done in the circumstances which is prohibited, and that's an exception provided in section 375 itself. So there are permissible and non-permissible conduct. And there are some offenses where the specific act itself is defined, like the offense of rape. It is provided. What is that? Now, there are some offenses which do not require act in very strict sense. In some sense, there is some act, like offense of criminal conspiracy. Now, offense of criminal conspiracy, if it is done, if criminal conspiracy is to commit an offense punishable with more than 2 years, any overt act is not required. The mere criminal conspiracy is enough. Your guilty mind, your conspiracy, your agreement, collaboration with the collaboration between 2 individuals is enough. Now, by some logic, it cannot be labeled as an act. Though, for the purpose of legislation, collaboration is the act. When 2 or more individuals conspire to commit an offense or something which is wrongful. In terms of law, it is act, but normatively speaking, it is not an act. How it can be an act? Act means making some voluntary movements. When you do an act, you do some movements. It does not involve some movement. So, criminal conspiracy. Similarly, if you look at the offense of dacoity, there's section 401 or 402, which talks about belonging to the gang of thieves or belonging to the gang of dacoits. Now, when you belong to a gang of dacoits, you haven't committed any act. You don't have a mens rea. So, it's an offense where you haven't committed an act, you don't have a guilty mind, but still you are liable. Because you are part of a bandit gang or a gang which is prohibited. Being a part of the gang in itself is crime. So some people may say being part of the gang is an act. But strictly speaking, it is not. So we talk in terms of conduct crimes and result crime, and we say that the act requirement manifests in various forms. Now we have this case of R versus Miller, which is also a drunken man case. And let me tell you, start with the facts of the case itself. Now, what are the facts of this case? Now, a person, he in a drunken state books a hotel room, enters a hotel room. After entering into a hotel room, he just lies down on the mattress. While he's lying down on the mattress, he lit the cigarette. Now, while he's smoking, the he don't know when he fall asleep and the mattress starts smoldering. It catches fire. Smoldering is a stage when what we say, dhua aata hai. When that dhua is coming, that's the stage of smoldering. So it hasn't caught the fire like fire as such, but it is smoldering. It has started burning. It's in the ignition stage. Now, after some time, he realized that the mattress is has started burning. So he moved to the next room and then he sleep there. In the morning, he found when the rescue team come that the entire hotel has burned. The question is whether he has committed any act. This person, Miller, has committed an act to burn the hotel. Now, if you carefully observe the sequence of events, what he did, he came in a drunken state. Whether coming in a drunken state is an offense, answer is no. He lit the cigarette. Whether lighting a cigarette is an offense, the answer is no. He slept while he was smoking. Whether that's an offense, answer is no. When he was sleeping, somehow, some reason, smoldering started happening because of the ash of that cigarette or because of that burning cigarette. Whether he contributed positively in that, whether he wanted that this mattress should burn and the consequently hotel should burn, the answer is no. So the question is, what are the principles of criminal liability? Why Miller should be held liable? So Lord Diplock in this case very carefully analyzed this maxim which I discussed in the previous slide. Actus non facit reum nisi means sit rea. There cannot be an act without a guilty act and a guilty mind. Lord Diplock said, yes, Miller is right. He hasn't committed any act. But we can't let him go. The problem is not with what Miller did. The problem is with the proposition, actus reus. Because the term actus reus signifies there should be some positive act, which is not required. Even act includes omission. So now you see in section 32 of the IPC that act also includes omission. But what are the foundational bases of act also including omission? This is the opinion of Lord Diplock in the case of R versus Miller. He said positive act is not required. So the very principle that in every crime there should be an act and guilty mind falls flat on the ground that even omissions are criminalized to some extent. Not all omissions are criminalized, but to some extent omissions are criminalized. And act includes omission. But when I said that the maxim is contestable, it is contestable on this ground. That act includes omission. Now, when I say omission is generally not criminalized, it is criminalized only when you have a duty. And then this duty can arise because or under three circumstances. It can be a legal duty. Law imposes some duty upon you that you should maintain your bank accounts. It can be a contractual duty. You entered into a contract. Say there is a swimming trainer and a person who is learning swimming. There is a contractual duty between these two people. Then there can be a fiduciary duty because of the nature of relationship, like between the trustor and trustee. There is a fiduciary relationship. There is a duty. And because of blood relationship, husband and wife, or any kind of natural any kind of these kind of relationships. Mother and son. If son is drowning, mother has a duty to protect the son. She can't say that law does not criminalize omission. There is a legal duty. You have to protect the son if the son is drowning. So there are certain situations where omissions are criminalized, but that's the case. That's where we started recognizing that it's not in every case where the principle of criminal liability is the positive act, but there are some cases where omissions are also criminalized. There are furthermore some problematic situations, which I have listed as 4 situations: state of affairs, possession, omission, automatism. I've talked about them in some indirect context. Now let me talk about them very directly. What is state of affairs? State of affairs means you find yourself in a state which is criminalized. Take an example, you are on Mumbai-Pune freeway. Now stopping a car on Mumbai-Pune freeway or expressway is criminal. You can't stop your car, right? If you stop your car, mind you that, I don't know if you know, the offenses under Motor Vehicle Acts are also offenses. They are also crimes, though very less stigma is attached. Jumping a traffic signal is also a crime. Speed driving is also a crime. Driving without seatbelt is also a crime. So is stopping a vehicle on the expressway is also a crime. Now you didn't yourself stop the car, the engine malfunctioned. So have you committed an act of crime? No. But even then you are liable. You are liable because you found yourself in the state of affairs. You found yourself in that position which is criminalized. Take an example. Many a time you do not intend or you do not want that your car should come on the zebra path. But because you immediately saw the red light, you stopped the car, and at that time you were on the zebra path itself. You could not cross the signal and you stopped the car. Traffic havaldar comes and see, your car is on the zebra path. You say, मैंने कुछ नहीं किया, I haven't done anything. I didn't know that signal will turn red automatically. But still it is criminalized because you are in the state of affairs. Take an example. One more example. You are in an alien country, in a foreign country. Say you went to Australia on a visa and you are a woman. Your visa expired and you have to go back. But fortunately, unfortunately, you were also pregnant at that time. 6 months pregnant. Because you were 6 months pregnant, because of the policy of airlines, you could not travel back to country. So you had to stay in Australia. Now you didn't want it to, you didn't do any positive act, but still you have committed the crime in the immigration law. You should have left Australia, but you could not. Now, not because of your positive state, because of your positive act, this is criminalized because of the state of affairs you are found in. It can be a situation that you went to Los Angeles and you spent all your fortune in the casino and you ruined your fortune. You don't have money to buy back the ticket. Your visa expired, your tourist visa expired, you could not come back. You have committed a crime in the immigration law. Now, though you have not committed the act itself, you didn't want it, but you find yourself in the state of affairs. So these are state of affairs offenses. Here the act is not required. So then the question is, what about the principle that in every crime there should be act and guilty mind? I haven't done anything. But the law says, as a rational and free agent, you must have known that if you are going to Los Angeles, if you are spending your fortune in casino, you should have adequate money to come back to your country. So you didn't do that. So you are liable under the immigration laws. Then possession offenses. Again, For possession offense, your act is not required. You are found in the possession of a psychotropic substance or a narcotic substance under NDPS Act of 1985. That in itself is an offense. Possession does not include an act. The fact that you are found in the possession of, say, take an example of cannabis, you are liable under that law. You're liable under that. Somebody might have put in your bag, but you are liable. The reverse onus clause comes. Now you have to prove to the court that somehow it slipped in your bag. But it's very difficult to disprove that because it's a strict liability offense. The law will presume the mens rea, the law will presume the guilty mind. Now, how will you disprove that you don't own that cannabis? Very difficult. So, possession offenses. Then omission, I have already explained. Similarly, series of act. If you look at section 33 of IPC, now we have under section 33 of IPC, that act also includes series of act. But in the case of R versus Miller, which I said, one way of justifying criminal liability was omission, and he had a legal duty that he should not let the hotel burn. But there are many questions, contestation on that. You can read the literature. But then other way of explaining, other scholars explain the liability of Miller on the basis of theory of series of act. They said, okay, there is no one act which is criminal. But when we look at the entire series of act, coming in drunken state, lighting the cigarette, sleeping on the mattress, then going to a different room, they're not doing anything about it. All this constitute the series of act, and that's why it is criminalized. Principle of criminal liability. Then automatism. Now, some time back, I was talking about the requirement of voluntary act. Now, automatism means automatic behavior. I put my hand like this and it fell down. I didn't do anything to make it fall, but it fell. Maybe because of gravity. Twitching of eye, I was telling some time back. Automatism. Somnambulism, that is walking when you are asleep. Automatism. You don't want to sleep when you are walking. You are not doing that voluntarily. But it is happening to you. Means there is some problem in the mind. I'm not sure if the problem is the right word, but there is some problem in the mind. That you are doing few things which you don't want to do. Sneezing. Now, sneezing is particularly problematic in COVID-19. Because if you sneeze in the public place, you may be held liable for spreading an infectious disease. So it's a serious offense in the health laws. If you sneeze in the public, sneezing itself separately is an offense also. Because you are endangering the life of other people, especially during the pandemic. Now you do not commit an act of sneezing. Sneezing is completely involuntary act. So all these involuntary movements which happens to you are called automatism. But not every involuntary act is automatism. So I gave an example earlier of somebody making you to kill and that person has put a pistol on your head or has kidnapped your son or has put someone in whom you are interested in the fear of life or grievous hurt. So those are also involuntary acts. So if you remember free consent, consent under contract act, all that is important here. Undue influence, coercion. So all those are the situations which are involuntary. The question is why there should be liability or should there be liability? So generally in automatism, you do not commit an act, but there may be some situation where you are liable. There are some situations where you are not liable. Ultimately depends upon the defense of insanity because the defense of insanity is usually applied to prove automatism. But what is insanity? Can you stretch the concept of insanity? to this extent. There are many debates about that. I don't intend to go into the validity of McNaughton rules or Durham rules as were let down in United States. Let's move to next point. I have 15 minutes. That this is my last slide also. Mens rea. Again, another solemn requirement which we talk about is the requirement of mens rea. That in every, there cannot be a crime without a guilty mind. You pick up any standard textbook by a criminal law teacher, you will find this line. And I found this line over and again whenever I read as absurd, as wrong. Because as I said earlier, there are so many offenses which are strict liability offenses. And therefore, making a blanket statement that there cannot be a crime without a guilty mind is itself a crime. It's an academic crime. So when we talk about mens rea, it's basically a fault requirement. The term mens rea is not used in the Indian Penal Code. Instead, the words like what we say intention, the words like fraudulently, dishonestly, knowledge, negligence, these are the terms which are used in the IPC to denote mens rea. But there are many offenses where these terms are not used, like intention, negligence, etc. But still there is a presumption of mens rea. And this concept of presumption of mens rea comes from the common law. In India, we had the case, a very famous case of State of Maharashtra versus M.H. George, or M.H. George versus State of Maharashtra. You can check who is the petitioner. The matter went to the Supreme Court before the division bench headed by Justice Subba Rao. And there was one more judge. Now, in that case, the court held that even in those offenses where the terms which denotes mens rea like intention, negligence, etc. are not mentioned, even then there is a presumption that the law requires, the section requires mens rea. So the court said, in order to identify whether the offense is one that which requires mens rea or not, you have to look at the object of the statute. You have to look at the language of the statute. You have to look at the intention of the legislature. By the mere absence of the word intention, knowledge, negligence, you can't conclude it's a strict liability offense. That's the judgment of State of Maharashtra versus M.H. George, a 1965 judgment, which was again upheld by a bench again led by Justice Subba Rao in the case of Nathulal versus State of MP. Now, there is a hierarchy of mental elements. So let me give you an example of offense of culpable homicide. Now, culpable homicide, if you look at section 299, how it is defined, culpable homicide is committed when there is an intention to cause death. Second, when there is an intention to cause bodily injury, which is likely to cause death. Third, knowledge, and that knowledge is likely to cause death. These are the three ingredients. So in section 299 itself, you saw two ingredients, intention and knowledge. So in order to understand the hierarchy, you have to refer to section 304. Section 304 has two parts, part 1 and part 2. Those culpable homicides which are done with intention, they have higher punishment. It exceeds 14 years. And those offenses where the mental element is only knowledge, there the punishment is less than 10 years. Then if you refer to section 304A, death by negligence, there the punishment is 2 years. So depending upon, say if it's an offense of murder, intentional murder, punishment can be death penalty. If the murder is with the knowledge that it is likely to cause death, punishment can be 10 years. And if the death is by negligence, punishment can be 2 years. So see, the consequence is death. Person has died. But punishments are very dependent upon your extent of guilty mind. At the top of it is intention, where you can be hanged. Below is knowledge, where you can be severely life imprisonment. And at the bottom is negligence. Few people also include the requirement of the recklessness. And then where do you fit requirements like dishonesty, fraudulently, etc., etc.? I'll leave it to you. But as far as offense of murder is concerned, these three are the gradations of the mental element. Then I have already talked about strict liability offenses. No need to speak about them. Liability offenses are an exception to the principle of mens rea. Then joint liability. Now, what is joint liability? Joint liability means you are liable for the act of other. Now, the principle is laid down in section 107, abatement. It is laid down in section 34, common intention. It is laid down under section 149, common object. It is also laid down in the offense of criminal conspiracy or dacoity. Technically speaking, you might not have committed an act, but you are liable because of the principle of the joint liability or the constructive liability. The vicarious liability principle is also brought in, like master servant liability. Now, generally, principle of vicarious liability does not apply in criminal law, but it does apply in some situation where master can be held liable for the criminal acts of the servant. So this is the concept of the joint liability. The concept of the joint liability also deviates from the popular maxim that in every act there should be an act and guilty mind, because in joint liability, technically speaking, every person might not have committed an act. You are liable because you are part of that group. You had a common object, and say you went for rioting, and during the rioting, there were 10 people, 2 people burned the bus, and 8 people were just standing there. You are liable not for what you did, you are liable for the common object which you had under section 140. So this is the principle of joint liability. So I think with this, I will leave 8 minutes for the question and answers. Thank you so much. I'll be happy to take any questions which you may have now.
Thank you, sir. Kaushal.
Yes, sir. Any
Go ahead,
questions?
Kaushal. I hope the participants.
Right. Sir, a lot of participants are raising their hands, I think so.
Okay, so will you unmute them and allow them to ask the question?
Kindly, I request the participants kindly put their question in chat box.
As sir said, all participants are requested to put their questions and queries on the chat box. Indeed, it was a great session. Thank you so much, sir, for enlightening us. And once again, on behalf of our college, all our attendees, I would like you to thank you, sir, for gracing this event with your sheer presence and your knowledge. On behalf of our principal, sir, Dr. Rao, sir, on behalf of all the attendees and all our coordinators,
Kaushal,
and
ask them
teachers who are
question
present.
first. Whether the
Sir, no, as such, there are no questions which I can see in the chat box as of now, sir.
1 minute. There is a question from Onkar Vedya. Please let us see the chat box. See, one question is there. Chirag sir.
Yes, sir.
Please explain the concept in brief about mens rea. One question is there from Onkar Vedya. Could you please elaborate more on mens rea?
Voltage, again, if I start explaining the term, it will take some
No problem, sir. No problem.
to explain the concept. It's a very broad question.
Yes,
Mens rea, in very simple terms, means guilty mind. So the term mens rea in the IPC is not used. It is used as intention knowledge. Now, the point is, I want to take an example. I have a mobile phone. I want to drop this phone and I have dropped it. I've dropped it intentionally. So this is mens rea. I intended to drop it and I dropped it. Take an example that you are trying to step down from Mumbai local. And because you are trying to step down from the Mumbai local, somebody fell who was standing aside in front of you. Now, Whether mens rea can be attached to you, yes, mens rea can be attached to you because you must have known or you must have had knowledge that if you try to come out of the train in a particular manner, this person who is standing in front of you may fall. He may lose the control or she may lose the control. So in that sense, the mens rea is again attributed to you. So mens rea is always attributed to you, and it is attributed to you based upon the conduct, based upon the circumstances in which the act is committed. I'm not sure, Omkarji, if you have read law of evidence. If you refer section 14 of the Indian Evidence Law, section 14 of the Indian Evidence Law makes state of mind relevant. So evidence can be given as to what was the state of mind of that person when that act is committed. It is for no purpose but to show whether the person had the guilty mind or not, or whether that person is done intentionally or not done.
Thank you, sir.
I think this must answer your
Yes,
question.
yes.
Yes.
We'll have the separate sessions on mens rea if you permit. I will arrange.
Sure, sir.
Sir, Chirag sir,
Yes, sir.
with your permission, we have the separate session as the time permits. Whenever you have the time, we'll have the separate sessions on mens rea.
I'll be happy to do that, sir.
Please go ahead. Kaushal, over to you. Sir, there is
Right, sir.
one question. Sir, there is a question from Prathamesh. Sir, can you enlighten us with that gray line between over-criminalizations and state liability to maintain public peace and tranquility?
I think Pratmesh has asked an excellent question, which is debated very highly in Western countries. Would be a very long answer. So what I would refer to Pratmesh is to read few books and articles. There is a book by Douglas Hurst on over-criminalization. What he has done, he has tried to identify the principle of criminal liability from the general part of the criminal law. And he said if these conditions are there, then we can say that there is no over criminalization. In fact, if you remember the traditional J.S. Mill theory of harm principle, that is also a principle of criminalization and used by Justice Indu Malhotra recently in the decriminalization of adultery judgment, wherein she said there is no harm involved. Though it's an outdated principle, but still it's a principle which demarcates that when state can use the principle of criminal law to maintain peace and public tranquility, and when the criminal law can be labeled as an instance of an over criminalization. So you can read the work of Douglas Hurst, you can read the work of Andrew Ashworth, you can read the work of Anthony Duff. In fact, Anthony Duff, along with four of his colleagues, has written 4 books on over criminalization and their efforts to identify the boundaries of the criminal law. It's a very, very complex question, but nonetheless, important question. And if you are interested, you can separately write me an email. I can also share the textbooks. So that's my response to you.
Thank you, sir. Sir, last question is there. Dr. Satyanarayana Kankalala
Yes.
from Vishakhapatnam. In India, many joint liability are punishable, but escape. How?
Sir, Satyanarayanji, if they are punishable, then how it can be escaped? It is punished means there is no escape. What probably you are saying is that there is a liability, but the courts are not punishing those individuals, or the police is not booking those people, charge sheeting those people, or prosecution is not framing the charges against those people. I believe that you yourself is learned and know that there are a couple of unfortunate practices in our criminal justice system which leads to this situation, like corruption, or because investigation is not conducted properly, or because nepotism. There may be various circumstances where connected people may not be punished or might escape. It may be also because there may not be evidence against those people who are connected. But as far as my understanding is concerned, Section 34 of IPC, which is an evidentiary rule, is used automatically wherever there are more than one individual involved in a crime, and police invokes joint liability in those cases. So ultimately, determination of guilt rests upon the court, and it is to be decided based upon the nature of investigation, the nature of evidence which is presented by the prosecution, and the kind of arguments which are made by the defense. So it's a complex exercise for which there cannot be a straightforward answer. Now, Galaxy J2 Pro asked, what is the meaning of alibi? This is not an evidence class, but still, for your sake, I'm explaining. Alibi is you are making a claim that you are not present, or you were not present at the place where the prosecution is claiming that you were there. So, take an example. I'm sitting here right in front of this desktop at Hiranandani Gardens, Powai. Taking a plea of alibi means I'm saying that no, I was not present here, I was present at Aurangabad. So that's the plea of alibi. It is usually used in order to say that you are saying that I have committed the crime, but it is not possible for me to commit the crime because I was not possible at the crime scene. So that's the plea of alibi. Any other question?
I hope you answered all the questions. There is one question from Pratibha Madam. What is the role of criminal liability while giving judgments?
Where is this question?
What is the role of criminal liability while giving judgments?
What is the role of criminal liability?
Liability while giving judgments.
No, I didn't understand this question, sir. Can you please explain me this question?
You only said that what is the role of criminal liability while giving judgments? Judgments are given on the basis of the criminal liability.
See,
Another
in a criminal case, there would be criminal liability, and the judgment which would be passed will either imprison you or will punish you with death penalty or will impose fine upon you. 5 kinds of punishment are mentioned in section 53. So if there's a criminal liability, there's a deprivation of liberty, or there is a deprivation of property by way of fine or by seizure. So that's the implication of the criminal liability in any judgment.
So one question is there from Nagra Shetty. This will be the last question.
Yes.
Henceforth, will not accept it. In any case, the prosecution is punishable for his intentional avoidance of proofs of winning the case rather than giving the justice to the victim's family in a murder case.
So basically, what Mr. Nagraj, if I have understood this question correctly, is talking about the illegitimate practices adopted by the prosecution, where the prosecution helps the accused instead of the victim family in a murder case, and whether the prosecution should be punished. Yes, if you can establish the case that public prosecutor was bribed and he conducted the prosecution maliciously or one-sided prosecution, definitely you can file a case against the public prosecutor, but you can't file a case against the judges. The immunity is only available to the judges. It is not available to the prosecutors. But the proof of this thing would be very difficult. Proving that prosecutor had a malice, or proving that prosecutor did this something. So the charges which would be levied against the prosecutor would be under Prevention of Corruption Act. So you have to prove that there's some bribe, there's some gratification involved, and that's why prosecutor. But merely because prosecutor negligently conducted the prosecution or didn't had the sufficient qualification or knowledge, then that's not the ground of prosecuting the prosecution in such kind of cases.
Thank you, sir.
Thank you. So,
Over to Kaushal. Over to you, Kaushal.
Right, sir. I thank all the participants and attendees who posed such good questions. And once again, I thank you, sir, for taking out time from your busy schedule and gracing this event with your sheer presence and knowledge. And it was our honor to have you, sir. And I'm sure we would all have learned something or the other, and we're surely going to implement it in our current legal knowledge. On behalf of the organizers, that is MLNG Society's Manikchand Pahade Law College, Aurangabad, our principal, Dr. Rao sir, all teachers, coordinators, and our dear attendees present here, I would once again like to extend a vote of thanks to our resource person for the day, Professor Chirag Balyan sir. Thank you so much, sir, for gracing this event.
Thank you, Kaushal, Mr. our Dr. C.M. Rao and Professor Dinesh Kolte and yourself deserves a lot of appreciation, as I said in the beginning, for inviting me and for organizing this wonderful lecture series. And I wish you good luck for the rest of the lectures which are remaining in this series. Thank you so much.
Thank you.
Thank you, sir. Thank you so much, sir.
Over to you, Kaushal. Please announce tomorrow's program.
Right. So so it is hereby informed to all of you that tomorrow as well, at the same time, beginning from 4, we'll be having the last and final day of this particular lecture series. The last lecture of this particular series would be taken by Dr. Nandini CP ma'am on joint criminal liability, and we'll be beginning from 4 in the evening. So all of you are again requested to please join in. The link will be shared soon. And you can also subscribe to our YouTube channel of Manikchand Pahade Law College for all updates. And this video as well would be updated on our YouTube channel soon. Thank you so much.
Thank you. Thank you all the participants. Kaushal. Thanks all.